Hey, this is attorney Elizabeth Potts Weinstein, and today we're going to talk about copyright versus patent versus trademark and which one of those legal frameworks applies to your situation. A copyright protects a creative work that has been memorialized in a tangible format under US law. So what does that mean? The work has to have some creative or artistic component. And when I say memorialized in a tangible format, I don't mean it has to be a piece of paper or a physical piece of artwork. It can also be something electronic. So examples of things that are protected under copyright law can be an article or book or some other written work. It can be music like the MP3 file of a musical work, or also the lyrics of a work and the composition of the music. Visual works like art, like photographs are also protected, and even things in the business world like a logo or illustration. The great aspect of copyright law is that there are some protections that happen automatically. You can also register your copyright, but you get some protections in the United States as soon as you put that work into a tangible format. Another great aspect is it protects you for a long time. It is the life of the creator plus 70 years after they die for most types of works. So there's a long period of protection. If you want to register your copyright, you can do that yourself, really, but at the United States Copyright Office's website, copyright.gov. You might want an attorney to help you the first time, but most people can do it themselves after that. A patent is where the government gives you a license to exclusively use an invention for a set period of time. The types of patents here in the United States are utility patents, which cover inventions, something that has a use, it's a process, it's a method, it's a physical product that you create that has some kind of use to it. There are also design patents over designs and plant patents. Examples of things you might patent could be a medicine or drug, it could be a medical device, it could be something that you physically can build, like you can patent the design of a camera, you can patent a toy design, you can patent an electronic device, you can patent a method of creating something or doing something or making something that you would do behind the scenes. The issue with anything you want to patent is that it has to be not obvious, it has to be something novel, and it has to have some kind of use for a utility patent. So the great aspect of a patent is you have dibs. You have exclusive use over that invention for 20 years from the date that you file the application for most types of patent applications. But the problem is that you have to disclose your invention to the public in the application. The application is incredibly detailed. You have a part where you describe the history in that area, you describe everything in your invention, so someone who is skilled in the art could reduce it to practice, could make the thing. And then you also have very specific patent claims. This is something that most people are going to have to hire an attorney to help them do because it is so legally detailed. It's also expensive to file a patent application, not only because you have to pay a lawyer, but all the fees before the Patent and Trademark Office. If you're a small business, the fees are reduced, but it's still not cheap. You can't patent something that is just an idea. You have to be able to disclose enough in the application that it can be reduced to practice. This is why you can't patent things that don't exist, like this beaming thing in Star Trek to beam people across the universe. Even if you wrote out a whole bunch of specs for how that would work, nobody can make that yet. And so you can't get protection for those kinds of ideas under patent law. For some things that you can patent that are used behind the scenes in your business, you may want to choose to protect that under trade secret law instead of patent law, because in theory, if you keep something secret and protected under trade secret law, you can have protections on it forever. Trademark law typically is going to protect the branding of your business. What trademark law protects are words, phrases, symbols, logos that are used in conjunction with the sale of products and services to identify the source of the products and services. So examples for trademarks could be the Nike Swish logo. It can be the name Nike in and of itself. It can be a slogan like "Just Do It." It can also be the names of products like MacBook or iPhone. When you file an application for a trademark with the United States Patent and Trademark Office, you have to go through an extensive process to get approved, similar to patent applications. It's not quite as long as patent applications usually, but it still is a process where your trademark is examined. So it's important to be aware of that. Some people can do their own trademark applications, but it does have some legal complexity, and there are little areas where you can get tripped up. The great thing about trademarks is that if you get your trademark registered, you could in theory have that trademark forever, as long as you keep using it in commerce and you keep filing forms with the Trademark Office and paying more fees every so many years to keep it maintained.